Hello everyone, my name is Katie Egan and I am with Foley and Lardner's marketing department. On behalf of Foley, we would like to thank you for participating in our Staying Competitive and Compliant in the EU web conference. At this time, all participants are enabled in listen-only mode. As a reminder, today's web conference is being recorded. Before we begin, we have a few housekeeping announcements. The presentation portion will last approximately 60 minutes. If you have questions, please feel free to enter it in the Q&A section of the web conference, and we will address as many questions as we can at the end of the web conference. In the Files section of your screen, you will find a copy of the presentation slides. The Files section also holds a very important document for any attendees seeking New York, New Jersey, or Kansas CLE credit. All New York, New Jersey, and Kansas participants must download the file titled Attorney Affirmation. A 4-digit class code will be announced during the presentation. You use that code to complete the form and then send it to me at kmegan@foley.com immediately following the presentation. My email address is also listed in the housekeeping notes section of the web conference and will be available when the class code is announced. And now I will turn it over to the moderator for today's web conference, Howard Fote. Howard, you may begin.
Thank you very much, Katie. Good morning, good afternoon. Thank you for attending this seventh in a series of annual webinars presented by Foley on issues related to doing business in the European Union. As the slide you're looking at indicates, the previous presentations have covered a wide variety of topics that we believed were pertinent in terms of both understanding the structure of competition compliance in the European Union as well as new and important developments that were occurring and had occurred during the preceding year. As always, the text and the audio of each of these webinars is available on our firm's website, and you will be able to access that with respect to this presentation in approximately a week. Today, we're going to cover some old issues and some new issues. We're going to cover some important priorities, things to keep in mind as you are working on company issues relating to competition compliance in the European Union. We're going to again talk about EU merger developments from a number of different perspectives, particularly the issues of simplified procedures and minority interests, which are new this year, as well as the continued bifurcation of merger control enforcement between the European Commission and the national competition authorities in the 28 member states. Distribution continues to be an important issue, not only for many companies in the United States doing business in the European Union, but also because it points out some significant differences between EU and U.S. antitrust and competition principles and enforcement. An important reminder that we will talk about during the middle of the conference is a notice on agreements of minor importance, the so-called de minimis notice, which should serve as a wake-up call for all of us who are counseling in this area. My colleague Sophie Lenier will talk about cartel developments, unilateral conduct, and the ever continuing dialogue in the EU to create and implement private damage action awards. We'll conclude with some prospects for this coming year. Again, as Katie said, if you have at any time any questions, please let us know. We've covered this background history in the past, and I want simply to reiterate again that the competition structure and priorities in the European Union are grounded fundamentally in the Commission's and the Union's desire to create a common economic market for all people in the European Union operating throughout the European Union. And this has really two basic elements: the elimination of barriers between member state trade, subject to some important exceptions, and then the creation of a system of competition principles and procedures working both at the European Union level as well as within the member states. Since 2004, there has been a revolution in competition enforcement and competition principles as the enforcement of these important principles has continued to devolve to national courts and national competition authorities. Today, there are 28 member states in the European Union. The slide lists the chronology, starting with the European Coal and Steel Treaty in 1951. Last year, Croatia became the latest member state. I think it's important to understand the economic implications of the subjects we're talking about, but in the context of the trade that exists between the United States and the European Union, for example. Keep in mind that 40% of world GDP and almost 50% of world economic activity is combined within the EU-US sphere. Foreign direct investment between EU member states and US states often dwarfs trade between the United States and China, for example, or trade between the United States and India. And so there are important interests that are at stake. As you may know, the United States and the European Union are currently negotiating a so-called free trade agreement, which will further eliminate the remaining barriers that exist between trade between the United States and the European Union, and competition policy will be playing a very important part in the creation of that common transatlantic market should these negotiations succeed. Competition remains a key driver in this process to create a single market. Throughout this webinar, we are providing information about links to information sources that will enable you to access the tremendous amount of material that's available on the EU competition website, for example. It will provide information about the basic treaty provisions that are relevant, similar to the provisions in the United States under the Sherman Act relative to horizontal and vertical restraints, as well as abuses of dominant position. Further, and in particular importance, it's essential to understand that there are a whole variety of legislative actions that can be taken by the key institutions, the Council, the Parliament, and the European Commission. And in many instances, those pieces of legislation have direct effect on business activity in member states. In addition, there are a plethora of notices and guidelines that are issued by the European Commission, for example, that play a role in assisting companies seeking to do business in the European Union with the likely safe harbor areas where they can operate without significant risk of enforcement action. So if you have issues in this area, look to the citations to the website in this presentation, which will give you a heads up and an opportunity to develop your research to a very refined level. We're going to talk first substantively about mergers. There are merger regulations both at the EU level and at member state levels. Each of the 28 member states has its own merger enforcement authority, and each of the 28 member state courts are competent under certain circumstances to deal with mergers that are affecting competition in their respective jurisdictions. However, there are thresholds which accord to the institutions at the EU level primary competence over merger regulations. If a particular transaction that is proposed to be consummated has what's called an EU dimension, and that evokes both an issue of worldwide turnover as well as turnover within the European Union, that transaction must be notified to the European Union Commission, and the parties to the transaction must wait a waiting period before that transaction can be consummated. Currently, if the parties to a transaction have worldwide turnover either in excess of $6 billion US or $3.2 billion, and at least turnover in 3 member states exceeding $128 million US, the transaction needs to be notified to the European Commission. We'll talk in a few minutes about the relationship to this, the relationship of this jurisdictional power in the European Commission to the member state authorities, because there can be transfers both to the member states under certain circumstances as well as transfers to the Commission as well. If, for example, a transaction does not meet the EU dimension thresholds, it can still be required to be notified to one or more member states. For example, with respect to Germany, if the parties to a transaction have combined worldwide turnover in excess of approximately $642 million, and if in Germany one party has roughly $32 million in sales and the other has slightly more than $6 million in sales, a filing to the German authority is required. Again, here is the citation to the merger control website at the European Commission. The important issues here are the existence, as I mentioned, of the notices and guidelines that will be very important in assisting you in advising your clients on how to proceed to get clearance, whether it be at the EU level or at a member state level. Of particular importance are the questions of notices on substance, horizontal and non-horizontal relevant market definition. Keep in mind that the definition of the relevant market will always be a very, very important question that will drive the analysis. In addition, the question of ancillary restraints, such as covenants not to compete, will be very important as you work with your clients to draft the acquisition agreement. So quickly to resume, there are shared responsibilities within the European Union on merger control. There are exclusive spheres of competence, but it is possible, as I said before, to either be required to file with the European Commission or with a member state authority, or conversely, member states can request that the European Commission take responsibility for a particular transaction that would not otherwise required to be filed at the EU level. Keep in mind that this legislation relates to so-called concentrations. It can encompass and control acquisitions, mergers, and certain joint ventures which are deemed concentrative. Let's look at some statistics that I think will be important to put merger developments in the EU into perspective. As you can see, the number of notifications of transactions to the EU Commission has been relatively stable over the last 4 years, roughly slightly less than 300 per year. There have been a small number of transactions each year that have either been referred up to or down to the member states. After the notification, as I said before, the parties are required to wait for a particular time period before the transaction can be consummated, and during that period of time, the parties and the Commission staff work together on the question of whether the notified transaction is compatible with the merger control regulation. And as you can see, in the vast majority of circumstances, the notified transactions are deemed to be compatible during the first phase of the investigation, subject to, in a few instances, the parties agreeing to commitments, whether it's a curative divestiture or some sort of licensing or other form of relief to satisfy the Commission authorities. If, after the first phase period runs, the Commission is still not satisfied, it can initiate a second phase investigation. You can see that that's very rarely done, but that is an additional period of time within which the transaction cannot be consummated, and the parties are required to work with the Commission to satisfy them. And if they are unable to do so, the transactions can be prohibited. Excuse me. Again, as you can see from the statistics, that's a very, very rare thing to occur, but it certainly does occur. Indeed, in this year, there were several transactions that were prohibited. The details of the particular transactions are not necessarily important, but what is important is the analysis by the Commission on the question whether the transaction would eliminate competition between the closest substitutes that provide competition for the benefit of the consumers. The United States deemed to eliminate such close competition, it's likely going to either be subject to possible prohibition or the need for a curative divestiture of some sort. Importantly, for the first time this year, 2 transactions were cleared Both of them were, in effect, mergers to monopoly, but the Commission concluded that the failing condition of the target company negated any possible anti-competitive consequences, and so permitted the transaction to proceed to consummation. In the case of Aegean Olympic, however, the parties were warned, as was the Greek government, that they needed to monitor very carefully competition developments post-closing, so that the Commission reserved the right to proceed if there was an unreasonable effect on competition. So what's new this year that's important? The first is that the Commission announced simplified procedures under its merger control regulation. Those now are in effect and will increase the number of qualified notifications that would otherwise be permitted to be filed under simplified procedures. You can see that you will need, in assessing whether those simplified procedures are applicable, to assess the relevant markets that are involved and determine whether the transaction qualifies from a market definition perspective. If so, there is a streamlined notification form which reduces substantially the amount of information that's otherwise required, and further reduces the extent to which the parties are required to interact with and negotiate in advance with the European Commission merger control staff. So the simplified procedures are now in effect. Another issue remains pending, and that is the June 2013 proposal to expand the merger regulations jurisdiction to review transactions that involve the acquisition of minority stakes in companies. Of course, the transaction would have to otherwise be notifiable under the merger control regulation in terms of turnover thresholds. But the EU, like other jurisdictions, for example, Brazil, are beginning to view seriously the prospect that limited minority structural links between companies can have important competitive concerns. And so this proposal is being advanced by the Commission. It is being subject to significant criticism in its present form because of concerns about lack of clarity and uncertainty in terms of its applications. So in terms of merger developments, several important case decisions, a number of legislative proposals, a number of continued examples of cooperation both at the EU and member state levels, as well as, importantly, cooperation between the United States and the European Union Commission in terms of international mergers that have important implications in many jurisdictions. We're going to turn now to distribution issues. We have covered these issues virtually in every one of the conferences because many of the people who are attending these webinars are interested in the issue of how to make sure that their distribution agreements comply with EU law. As those of you who have attended before know, there are important differences between U.S. and EU law. We'll cover those briefly. There are as well important developments that you should know in terms of how distribution law in the European Union is being enforced. And we'll talk briefly about the de minimis notice that I mentioned previously. The first and important thing is to know that during this past year, there were no EU cases involving vertical restraints. The action continues to increasingly be at the member state level, while the European Commission continues to provide guidance through notices and guidelines. The action in terms of enforcement remains increasingly at the member state level. An issue that we have discussed many times before is the question of resale price maintenance. In theory, the Commission suggested that in certain circumstances, resale price maintenance could be permissible. However, that remains a very, very hard sell in the EU. There have been a number of cases. We discussed the recent Cour de Cassation case in France involving the perfume industry, in which significant fines were imposed on companies engaged in resale price maintenance. Similarly, recently in Poland, significant fines were imposed as well for resale price maintenance. So, in addition to RPM, the rules for exclusive and selective distribution in the EU remain much less favorable than in the United States. It's important in assessing your distribution agreements to make sure that they not only comply with U.S. laws, which tend to be relatively relaxed, but also with respect to EU laws, which in this area in particular are much more restrictive. There are evolving rules on online sales, and I'm not going to spend a lot of time on them. The slide materials, as well as the guidelines on vertical restraints on the Commission's website, will provide important information on online sales. So again, just to emphasize, there are major differences from U.S. law, particularly in the areas of resale price maintenance and in the area of minimum advertised pricing, or MAP. The issue is made more complex by reason of the fact that in the United States, while RPM is now theoretically permissible under federal antitrust laws, it remains the subject of great controversy at the state level, and there are many states that continue to prohibit under their state antitrust law resale price maintenance. There is a website to an ABA publication, the Antitrust Source, which regularly updates the laws in all 50 of the United States with respect to RPM developments. And I would urge you to look at that.
Okay, thank you, Howard. So now we're going to go over the cartel enforcement in the EU and start with some cartel statistics. As shown on this slide, the Commission slightly exceeded its 2012 fines with a total of 1.9 billion euro fines imposed last year. The significant enforcement figures for 2013 are also entirely due to the record fine of euro 1.7 billion imposed on banks for manipulation of the LIBOR and Euribor benchmarks. And the number of cartel decisions for last year were not so many. We had 4 commission decisions imposed on a total of 19 undertakings. To go very briefly over these commission decisions, the first one, which was taken in July, was with respect to the auto parts cartel. The European Commission fined 5 car parts suppliers a total of 141 million euros for operating 5 cartels for the supply of wire harnesses. The cartels covered the whole European Economic Area, and one of the infringing company, Sumitomo, received full immunity for revealing the existence of the cartel, and thus avoiding a fine of 291 million for its participation in all the 5 infringements. All the parties also, it's important to note that they benefited from reduction under the leniency notice for their cooperation, and the Commission agreed also of a 10% additional reduction in the fine since the companies acknowledged their participation in the cartel and their liability. The second decision involved the European North Sea shrimp traders that affected the EU market, and in particular sales in the northern part of Europe, Belgium, France, Germany, and the Netherlands. And the Commission imposed a total fine of 28 million. And again, it's one of the company that bring the cartel to the attention received full immunity in this case. The last 2 decisions that relate to the interest rate derivatives industry. The Commission imposed a record fine of euro 1.7 billion. It's the highest cartel fine ever imposed by the Commission on 8 banks for manipulation of the LIBOR and Euribor benchmarks. Both decisions were adopted by the Commission's cartel settlement procedure. So the company's fines were reduced by 10% for agreeing to settle. Full immunity was received by 2 banks, UBS and Barclays, for revealing the existence of the cartel. And several other banks also received a substantial reduction in the fines for cooperating with the Commission. It's to be noted that it's not the end of the investigation, as the standard procedure continues with the banks that did not agree to settle with the Commission. Also in the pharmaceutical sector, I would like to mention the Lübeck decision. The Commission imposed a fine of 93 million on the Danish pharmaceutical company Lübeck, and a fine of 52 million on the producers of generic medicines for entering into the so-called pay for delay agreements for generic versions of a major depressant drug. In this case, the basic patent had expired, and the remaining patent protection was limited to certain manufacturing processes. But the generic companies also had the possibility to enter the market. But instead of competing, the producers agreed with Lübeck not to enter the market in return for substantial payments. There are several other similar cases that are pending before the Commission. And recently, last month, also the Commission imposed a fine of 16 million on Johnson & Johnson and Novartis for delaying market entry of cheaper generic version of a painkiller, the fentanyl, in the Netherlands. So to summarize, there were not so many decisions taken by the Commission last year. There are, again, a great number of ongoing Commission investigations in various sectors, such as the auto parts market, but also the foreign exchange rate manipulations, and which are likely to be decided this year. An important point also is that the EU leniency program is confirmed as being a successful and powerful tool for the Commission to detect the cartels. As you've seen, most of the decisions are now based on immunity applications. And regarding the process for settlement procedures, The process gets shorter and covers now most of the cases. There were no appeals, so we can say that it's now a well-established instrument for cartel enforcement. And as the European Competition Commissioner said, it sees the settlement procedure apply to half of the cartel cases in the near future. Now let's turn to the cartel rulings and the main general principles that have been developed by the courts. There were many cartel appeals, and among them some interesting ones. We start with the first one is that I'd like to mention is a Donner ruling covering the issue of third-party access to documents in cartel proceeding. It was in the context of, in this case, of preparation of an action for damages. A request was made to access documents forming part of a file in national cartel proceeding. The national law precluded third-party access to the court files and without the consent of all the parties to the proceedings. So in this case, as expected, all parties had refused the access, thus rendering any damages actions extremely difficult. So the court said in that respect that any absolute rule for non-disclosure is too rigid and incompatible with EU law. National courts shall decide on the conditions for granting access by weighing the respective interests in favor of disclosure and the protection of that information. Another interesting ruling is the Schenker judgment. The companies had entered into a price agreement that was qualified as a minor cartel by National Competition Authority and was not sanctioned under national law. The parties also had sought the advice of legal counsel that confirmed the decision of the National Competition Authority. And the day the case was brought to the attention, the proceedings were initiated, and as the conduct of the companies could breach EU law. So the parties for their defense argued that they cannot be fined for a breach of 101 since their practices had been viewed as lawful under national law. But the court clarified that companies cannot be unaware of the anti-competitive nature of the conduct, and in any case, the national competition authorities do not have the power to adopt negative decisions, meaning a decision concluding that there is no infringement of Article 101 and that therefore they cannot cause undertaking to have a legitimate expectation that their conduct does not infringe Article 101. Another interesting ruling is the one handed down last September by the General Court that partially annulled the Commission's bathroom fittings infringement decisions, and the result of which the fine of one of the companies was substantially reduced. The court said that it cannot be presumed that exchange of commercially sensitive information between non-competitors is a breach of Article 101. A company sharing its pricing information with companies active on other product markets cannot be presumed to have infringed EU law. On the contrary, such information exchange is not capable in principle of having an impact on competition on the market the exchange information relates to. So it's therefore, the court insisted on that, it's up to the Commission to demonstrate that competition was affected on each separate product market covered by the single infringement. There were also so many rulings on parallel liability. As you may know, in the EU, there is an expansive approach to attributing liability to parent companies for breach of EU competition rules committed by companies within their corporate group. In that respect, the AXO ruling still stands. A parent is liable for the activities of its subsidiary as long as it exercises decisive influence over that subsidiary. It is reconfirmed in the ruling that was taken last year. The parent had argued in that case that they had done their utmost to prevent the subsidiaries from engaging in conduct contrary to EU law, and they had implemented a compliance program among the subsidiaries. But the court said that respect and rejected the argument, saying that in the implementation of a compliance program demonstrated that the parents did in fact exercise control. So decisive influence, the court said, is a question of economic reality, not company law. So therefore, the existence of separate legal personalities or economic autonomy of the entities is irrelevant. Equally, the legal form, the entity holding the shares in a subsidiary is irrelevant. In that case, the parent company was not an undertaking but a foundation. But the argument was rejected and liability established. The court also confirmed, it's an interesting ruling, the parent liability for infringement committed by joint venture over which the parents exercise decisive influence. Such influence may exist even if the parent did not participate in the breach and knew nothing about the joint venture's infringing conduct and could only better the decisions but not determine the strategic business decisions of the joint venture. In this case, the court pointed out that the parties had appointed some senior managers of the GV and emphasized that the parent liability also applies to full function joint ventures. So the fact that the GV has a degree of operational autonomy does not mean that the parent cannot have decisive influence. The court also recalled that presumption of parental liability is a rebuttable presumption and therefore compatible with the presumption of innocence. To escape such liability, the parent shall give evidence that he did not exercise any decisive influence over the strategic decisions of the subsidiary and that the subsidiary acted independently on the market. In practice, however, it proves to be extremely difficult to rebut such a presumption. Let's turn now to some policy issues, and I would like to highlight that the Commission adopted revised guidance on conduct of the downgrades. The guidance codifies the Commission's current practice. Rated companies shall fully and actively cooperate with the Commission, and in particular the IT staff needs to be made available to assist the Commission's team. The guidance also reiterates the powers of the Commission inspectors in general terms, in the sense that they can enter any premises of the undertaking, examine the books, seal any business premises, and require on-the-spot oral explanations for any facts or documents relating to the inspection. And also the guidance more specifically provides information about the rights of inspectors to search the IT environment and storage media, including laptops, tablets, mobile phones. In that respect, the Commission collects information using its own search tool called NUIX, and the demo is available on the DG Competition website. Also, at the end of the inspection, inspectors may take a secret copy of the data still to be searched back to the Commission premises to continue the selection process. And finally, what is important is that this guidance reaffirms the right for undertakings to consult with the external legal counsel during the inspection, but it says also that any delay in arrival must not impede the investigation. So the Commission accepts only very short delays before starting inspection. And while companies may counsel a legal advisor, this is not a prerequisite for the legality of the inspection, and inspectors may enter the office without waiting for legal advisors to arrive.
Sophie, may I make one comment?
Sure.
Well? And that is that remember, particularly for United States attorneys, that the advice that they give to their European clients may not be protected under the rules of the attorney-client privilege vis-a-vis the European Commission. And so you need to proceed very, very carefully in that regard. The same can be true with respect to in-house counsel who may not be accorded the same kinds of privileged and confidential communication rights that we take for granted in the United States. Thank you.
Thank you. Also, finally, I'd like to just say a few words about the new guidelines adopted by the Commission on the delivery of oral corporate statements for leniency applicants. The EC guidance is very technical and factual. It says that all corporate statements shall be clear, factual, and to the point, focus on the alleged cartel activity, but should not go as far containing general market information, and cannot in any case contain business secrets or confidential information. And the guidance also recalls that statements are recorded and that it's up to the applicants to check the accuracy of the audio files and the commission transcripts. As you know, today it's common practice to make such oral statements as they cannot be accessed by third-party claimants in follow-on damages actions. Now let's turn to Article 102. There has been it has been a very busy year in that respect in the field of technology. I would just say very briefly a few words on two main cases, Microsoft and Google. As you may know, Microsoft was fined a total of $561 million for failing to implement its commitments, and the Commission, it was the first time the Commission imposed such a fine for a breach of commitments, and shows also the seriousness with which the Commission will take action in case of breach of binding commitments. Also, briefly, the Commission continued to discuss remedy with Google. As you know, Google is alleged to be dominant for web search and search advertising. So Google, in that respect, offered commitments to address the Commission's concerns. But the first commitments received negative feedback, and the Commission asked Google last summer to improve its proposal, and there were new revised commitments that were submitted last fall and market tested with interested parties. Turning to those very interesting cases on standardization patterns, as you may know, the Commission has 3 ongoing formal investigations against 2 companies, Samsung and Motorola, alleged to have infringed 102 by failing to comply with their commitments to standard-setting organizations to license SEPs on friend terms. So the Commission is, in this case, is investigating whether, by seeking injunctions to enforce their standardization patterns, whether Samsung and Motorola have abused their dominant position when the injunction is against a company willing to enter into license on friend terms. Seeking injunctions is it's a legitimate remedy for patent holders in the case of patent infringements, but access to SEPs is also a precondition for any company to sell interoperable products. So according to the Commission, to seek an injunction based on SEPs, that may constitute an abuse of dominant position if the SEP holder has given a commitment to license its SEPs on friend terms, and where the company against which an injunction is sought is willing to enter into an agreement on those terms. So the Commission sent a statement of objections to Samsung and Motorola, and to address these concerns, Samsung this fall proposed commitments to address these concerns. I'd like to mention in that respect on this same area that in addition to these Commission action in this area, there has been there's an interesting case that is brought by the German court that referred a request for a preliminary ruling to the Court of Justice of the EU, covering many of the issues that the Commission has been investigating. So this year should be of particular interest because we expect likely completion of both the Samsung and Motorola case and the ruling of the court. Now let's turn to private antitrust enforcement. In June, the Commission finally adopted its long-awaited proposals aimed at promoting private antitrust litigation in the EU and introducing a new legislation comprising a directive, setting up rules governing action for damages under national law for competition law infringement, some guidance on quantifying antitrust harm, and a recommendation on collective redress mechanism. To start with the directive, the key provisions, it requires member states to introduce new rules permitting national courts to order disclosure of evidence by a defendant. Sorry.
We need to take a brief minute to announce the Kansas, New York, and New Jersey CLE code. As a reminder, all Kansas, New York, and New Jersey CLE attendees need to download the attorney affirmation code form found in the file section and enter the 4-digit code that will be announced at this time. Complete the form and email it to me at kmegan@foley.com. My email address is there on the screen. The code is QOB as in boy, S as in Sam. That's QOB as in boy, S as in Sam. Back to you, Sophie.
Thank you. Yes, so let's go over the key provisions of the directive. As I said, the directive requires the member states to introduce new rules permitting national courts to order disclosure of evidence by a defendant or a third party, whether or not that evidence in the file of a competition authority. The disclosure should be, in that respect, the directive says should be proportionate. There is no general disclosure, but such disclosure should be specific, proportionate. There should be proportionate disclosure of the relevant evidence. Also, the member states shall ensure that national courts have at their disposal effective measures to protect confidential information from improper use. And that respect, the directive sets important limits on access to a competition authority's file. The provision says that national courts cannot at any time order a party or a third party to disclose leniency corporate statements and settlement submissions. Further, the text of the directive states that national courts can only order disclosure of certain types of documents, such as replies to statement objections, reply to requests for information, only after the competition authority has closed its proceedings or taken a decision on the matter. An interesting development is also the inclusion of some protection for the immunity applicant from damages claim. The proposed directive states that such applicants are able to injure parties other than its direct or indirect purchasers when compensation cannot be obtained from other undertakings that were parties to the infringement. The directive also states that undertaking involving in joint behavior should be jointly and severally liable, and that an infringing undertaking should be able to recover a contribution from other infringing undertakings based on their relative responsibility for the harm caused. The directive also confirms that the defendant can invoke as a defense the fact that the claimant passed on the whole or part of the overcharge resulting from the infringement. The burden of proof rests with the defendant. However, the defense will not be available in the case where the overcharge has been passed on to persons for whom it is not possible to claim compensation for the harm. Importantly, and also controversially, is the proposed directive states that it shall be presumed that the infringement caused harm. This is a rebuttable presumption, and the infringing undertaking should have the right to rebut this presumption. And to complete the picture.
If I may
yes.
interrupt briefly, that's very, very contrary to what would be the case in the United States, where there is no such presumption.
Mm-hmm. Thank you. And so to complete the picture of the European Commission's legislative package of proposals, it should be noted that the Commission also issued a communication on quantifying harm and actions for damages. It is intended to assist the national courts of the parties on how to quantify antitrust harm in order to ensure full compensation. The main point addressed by the Commission is that national rules on quantification may have to provide for best estimates or equitable considerations, otherwise compensation may become extremely difficult. The Commission also published a practical guide on quantification of harm, providing an overview of the methods and techniques available to estimate the harm suffered as a result of the antitrust infringement. This information on quantification is is purely informative and certainly not binding on the national courts or the parties. The Commission finally also published a recommendation on collective redress mechanism for violation of EU rights. It is intended to complement the damages directive in relation to competition law infringement, but the recommendation is intended to apply more broadly to all breaches of EU law. It sets out a number of common principles and procedural safeguards to facilitate such actions. To conclude, the Commission makes it clear that victims of infringement of EU competition rules must have access to effective mechanisms for obtaining compensation across Europe. However, it is to be expected that there will continue to be a lively discussions about it. The introduction of disclosure rules in antitrust claims will be controversial in many EU member states because the lack of disclosure in many states is the main problem to date. The most important clarification is, however, the protection of leniency corporate statements for disclosing damages claims, thus removing the uncertainty that there was laid by court ruling in the federal judgment. I'll turn it over now to Howard for the concluding remarks. Thank you.
Thank you, Sophie, very much. And I apologize for losing my voice before, but I think I have got it back for at least for a few minutes. So what lies ahead? I think as the presentation we've made today indicates strongly, there are important reasons why competition compliance policies and procedures will continue to be very critical for people trying to do business successfully and within the context of EU law to avoid the very draconian and significant penalties that can be imposed. There have been and there will continue to be important differences between U.S. and EU law, particularly in the area of vertical restraints. In terms of the de minimis rule, I think it's very important to understand that even if you have a very, very small share of a particular market in the European Union, if you are engaged in per se prohibited activities, price fixing, exclusive distribution as they would define it, resale price maintenance, you can be liable under EU antitrust principles. There is the continuing level of uncertainty with respect to merger rules, particularly as it relates to the acquisition of minority stakes in EU enterprises. As should be evident from the statistics that Sophie presented, the EU Commission's cartel war will continue and intensify. Indeed, in the last month of 2013, fines of almost 2 billion euros were imposed on cartel participants. And finally, just as it is important in the United States, so it is increasingly important in the European Union to be aware not only that you have potential rights to redress competition injuries that you suffer, but also that you may be subject to claims to recover damages for those rights in any one of the 28 member states in which you're doing business. I want to thank you for participating in the conference today. If there are any questions, we'd be delighted to try to answer them as well. Thank you very much.